The U.S. Supreme Court's controversial move, undoing voting rights protections. The Voting Rights Act, a cornerstone of racial equality in American democracy, is on the brink of being dismantled. The Supreme Court's recent oral arguments in Louisiana versus Callais suggest a willingness to strike down Section 2 of the Act, which has been pivotal in safeguarding black voters from racial gerrymandering. But here's where it gets controversial. The court's potential decision could effectively nullify the entire Voting Rights Act, a law that has been instrumental in the fight for civil rights. The case's origins lie in Louisiana's post-2020 census redistricting. Despite a population one-third black, the state initially approved maps with just one majority black district, rejecting fairer alternatives. Voters challenged this, and federal courts mandated Louisiana to redraw maps, ensuring black voters equal representation. However, a group of non-African American voters have now sued, arguing that the Voting Rights Act enforcement infringes on their rights under the 14th and 15th Amendments. They claim that the Act's remedy for racial discrimination against black people is, in itself, discrimination against non-black individuals. This argument resonates with the Supreme Court's conservative majority, who have historically shown skepticism towards the Voting Rights Act. In 2013's Shelby County versus Holder, the court weakened Section 5, which required states with a history of racial discrimination in voting to seek federal approval for changes to voting laws. This decision led to a surge in new voting restrictions, widening the racial gap in voter participation rates, especially in previously regulated districts. During the oral arguments, Justices Kavanaugh and Alito suggested that the racial gerrymander could be justified if it was intended as a partisan maneuver, disregarding its discriminatory impact. This stance contradicts previous Supreme Court precedents and congressional records, which emphasize that discriminatory effects, regardless of intent, constitute illegal racial discrimination. Justice Ketanji Brown Jackson passionately argued against this interpretation, but her colleagues seemed unmoved. The case exemplifies the Roberts Court's tendency to undermine racial justice claims and reinterpret civil rights laws to reinforce historical racial hierarchies. Louisiana's Attorney General, switching sides, argued that assuming black voters would vote differently from white voters is unconstitutional. This claim, however, was met with skepticism by Justice Kagan. Chief Justice Roberts has consistently opposed efforts to address racial discrimination, advocating for race-blind policies despite their potential real-world discriminatory effects. If the court rules in Louisiana's favor, it would effectively legalize racial gerrymandering to diminish black voter power while making it illegal to use race to enhance it. The court's reasoning suggests that any attempt to protect black voters' rights is seen as a violation of the very amendments designed to guarantee those rights. The potential nullification of the Voting Rights Act is more than just a legal debate. It's a matter of preserving the integrity of American democracy. If the Supreme Court sides with the non-African American voters, it could significantly impact the upcoming midterms, potentially benefiting Republicans. This decision would not only affect the legal landscape, but also the political balance of power. The Supreme Court's actions have sparked intense debate, with many questioning the court's commitment to racial equality and justice. Are these decisions a step towards a more inclusive democracy, or a regression to a darker past? The court's interpretation of the law and its impact on the upcoming elections will undoubtedly be a topic of heated discussion and controversy.